So thank you for being here and for attending this last panel session of this three-day conference. I think that our work will be quite complicated because after the last session, which was extremely important, extremely moving also, very emotional, we will have to bring you back to more technicalities, and this is a difficult role, I think, for
this is why the room is empty. So.
It's also important.
We'll try to bring them in. I just wanted to say that some words about the Greek case in the Council of Europe, because I really believe that it was an extremely important moment for the European history. For me personally, because of the Greek case, to some extent I have decided to look into constitutional law and human rights and work for the Council of Europe. But I think above all because the Greek case has shaped the Council of Europe in one way. We must realize that at the time that the case arrived in Strasbourg, the Council of Europe was an organization that looked into almost everything that happened in Europe, apart from the military aspects, apart from the European Convention of Human Rights and the European Social Charter and the European Cultural Convention. There were plenty of other conventions about extradition, about cooperation in criminal matters, transfer of horses, les filles au père, so the civil insurance about civil insurance, or insurance about civil responsibility for cars moving around Europe. The green cards that all of you have is a Council of Europe Convention. Nobody knows it, but never mind. But it is actually the Greek case that gave to the Council of Europe this human rights orientation that made the organization able to call itself the democratic conscience of Europe. And this is important because through this process, the European Convention of Human Rights became not only the major instrument, the jewel in the crown of the Council of Europe, but an essential instrument of European public order. The human rights have been put at the basis of the European integration. The procedural aspects of protecting human rights at the international field became central to the political discussion, and the political discussion and the political process was there to support the legal process and not vice versa, which was an important shift in the policies in Europe. And this has led to the reinforcement, perhaps not only the Greek case, but also the case that followed, the case against Turkey, to the conviction that there could not be an European integration without individual application, that it could not be an European integration without a court with compulsory jurisdiction, which was not the case until then. Protocol 11 that merged the court and the Commission was there. And I will also say that even for the European Union, the Greek case was important because it is thanks to this process of making the European Convention of Human Rights central to European integration, the European Union has integrated progressively as an organization of financial character at the beginning, has progressively integrated notions of rule of law, human rights, and ultimately also democracy in its process. And we see how important this process is today with the problems of the infringement proceedings before the Luxembourg Court, the proceedings, the discussions and the dialogue under Article 7 of the treaty, the European Union, Article 6 of the Lisbon Treaty, which obliges the European Union to accede to the European Convention. So a number of important elements of the European progress are due to the Greek case and to the attitude of the organization, which at the time was also important to show, perhaps at the time of the Cold War, where the protection from totalitarian authoritarianism was important to show that there are some limits in the protection means. It was a message for Europe. I think it was also a message to the other side of the Berlin Wall that dictatorships are not tolerated in the Western world, but above all, they are not tolerated in Europe. And that what the United States have pursued to some extent in Latin America or that scope was not something that was tolerated in Europe. From this perspective, I think that it shaped the whole European conscience for years and for generations. So with these words, which are very personal, I would first of all like to give the floor to Vasiliki Saranti from the Ministry of Foreign Affairs of the Hellenic Republic, which will make a presentation on the interpretation and implementation of the derogation clauses, the very central notion of the European Convention of Human Rights.
Thank you, Mr. Chairman. It is really difficult to take the floor after the previous very emotional session, but I think Mr. Giakoumopoulos was the perfect bridge, and this makes our life easier. Yes. First of all, I would like to congratulate the organizers for this initiative and for organizing this very special bunch of discussions. I'm personally very honored to be part of this conference. States of emergency and derogation clauses was the subject matter of my PhD thesis. So the Greek case was for me a very central point of departure when I started my research. And actually it was the first case that we had seen the full-fledged implementation of practice of derogation clauses and a full-fledged examination of the legality of this dispute. So I will mainly deal with two issues in my presentation that revolve around the state of emergency that was declared on the 21st of April by the military junta, and the subsequent triggering of Article 15 of the European Convention on Human Rights. The state of emergency was notified to the Council of Europe by the then Greek permanent representative in Strasbourg by means of his letter dated 3 May 1967. Greece, represented by the colonists, filed an almost blanket derogation from the European Convention on Human Rights, communicating the infamous Royal Decree 280 that suspended a series of constitutional provisions and actually established the dictatorship. The derogation covered the period from 3 May 1967 until 13 June 1970, when the denunciation of the convention and the withdrawal/expulsion came into play. The legal basis for the verbal note was Article 15 of the European Convention on Human Rights, dealing with states of emergency and the right to derogate from certain provisions. The legal legacy of the Greek case is important for two reasons. First of all, for the assessment of the notion public danger by the European Commission on Human Rights and its impact on subsequent jurisprudence. And secondly, for the assessment of the legitimacy of acts issued by illegitimate or unconstitutional governments. Let us start by the definition of public danger given by the Commission. Article 15 of the European Convention on Human Rights aims to respond to situations of utmost urgency and severity. It is not a provision aiming to regulate everyday life. It is not a provision suited for normalcy. It is, in other words, a provision of last resort. And this is clear from the wording of the first paragraph of the article, which states, in time of war or other public emergency threatening the life of a nation. This is where derogations can come into play. Tons of paper have been disposed in order to explain the meaning of this phrase. The Greek case has been a landmark in that it demonstrated that an objective definition of a threat is actually feasible and that it lies outside the raison d'etat doctrine. The decision on whether to proclaim a public emergency is an actively impairing. Although emergency measures can be scrutinized by international courts and institutions, the raison d'etre still permits to some extent human rights jurisprudence. In the case of derogation clauses, the raison d'etre is still present in the assessment of the existence of a real danger that threatens the life of the nation. Indeed, the European Court of Human Rights is usually hesitant in analyzing the danger. To the contrary, it prefers to assess the proportionality of the measures adopted to deal with the danger. This approach is based on the premise that national institutions, such as the executive and the legislative, are closer to the facts that trigger the national emergency, and thus in a better position to evaluate whether the situation threatens the life of the nation or not. The Greek case marked a clear exception to this firm stance, since the claim of the Greek government that the measures adopted were necessary to avoid the communist danger was unequivocally overruled by the Commission. It was the first time that it became obvious that the field of the sovereign acts of state is shrinking under the normative pressure of international human rights law. The Commission gave four characteristics of the danger under Article 15. First of all, it must be actual or imminent. Secondly, its effects must involve the whole nation. Third, the continuance of the organized life of the community must be threatened. And fourth, the crisis or danger must be exceptional in that the normal measures or restrictions permitted by the Convention for the Maintenance of Public Safety, Health and Order are plainly inadequate. These four requirements constitute, until today, an authoritative definition of the state of emergency that can trigger the application of the derogation laws, and are used henceforth repeatedly in relevant jurisprudence, insofar as international human rights organs decide to delve into the assessment of the emergency as such. The practice shows that when the national emergency is proclaimed by legitimate governments, the European Court of Human Rights usually defers to national institutions. This was the case with the United Kingdom in its long battle with the Irish Republican Army, and lately in the war against terrorism. In the latter case, it even deviated from the definition given by the Commission in the Greek case, especially as to the imminence of the danger. This is the case more recently with France, Ukraine, and Turkey. And this brings us to the second feature of the Greek case jurisprudence. Constitutional governments that establish a strict legislative and judicial oversight of the derogation measures enjoy the presumption of safeguarding the nation's interests. Unconstitutional governments lose any legitimacy in this domain whatsoever. International case law affirms that one of the fundamental elements of the derogation clauses is the principle of legality. The provisions on the declaration of a state of emergency must already exist in the constitution of the state, and they have to provide for control mechanisms at the legislative and judicial levels. The Commissioner for Human Rights, evaluating the UK derogation in 2001, reaffirmed that parliamentary scrutiny and judicial review represent essential guarantees against the possibility of an arbitrary assessment by the executive and the subsequent implementation of disproportionate measures. Within the Inter-American Human Rights System, the Inter-American Commission on Human Rights, in its resolution on the protection of human rights and the suspension of constitutional guarantees, emphasized that the declaration of the state of emergency must not entail a curtailment of the rule of law or the constitutional provisions, nor an overthrow of the constitutional order, or in general any alteration in the separation of powers. The Greek case legacy has been applied in the situation in Chile after Pinochet has declared a state of emergency and established the first dictatorship of law, and in the Somoza regime in Nicaragua. In the latter case, the Organization of American States has even questioned the legality of the government and asked for its immediate replacement by a democratic regime. The most recent and clear-cut example of the lack of legitimacy of an unconstitutional government to resort to the derogation clause, especially in order to consolidate its rule, is the political crisis of 2009 in Honduras. The so-called constitutional coup d'etat prompted the swift reaction of the Inter-American Commission on Human Rights, which reaffirmed that the principle of governmental legitimacy is included in the substantial requirements of the lawfulness of the derogation clause. The first of the requirements established in the Convention for a suspension of guarantees to be legitimate is that they are adopted by a government that exercises public power legitimately within the context of a democratic society. A continuing challenge, though, is the gradual erosion of the rule of law following the declaration of the state of emergency and the infiltration of emergency measures in the ordinary legislation, even after the state of emergency has been lifted. For example, as was the case in Turkey, which has lifted the state of emergency in 2017, but has included its provisions in normal legislation. The Strasbourg Court did not have the opportunity yet to adjudicate on this. Most of the cases have been declared inadmissible due to failure to exhaust domestic remedies. But I feel that the word challenging for this type of cases is clearly an understatement. The Greek case has paved the way on how international institutions should scrutinize emergency measures. There is no reason to deviate from this legacy, especially nowadays, when the boundaries between legitimacy and illegitimacy are so blurred. Thank you very much.
Thank you very much, Vasiliki. I think it was really important to show how the Greek case and the interpretation of Article 15 defined actually the striking of sovereign rights of states and the importance of the judicial review and perhaps the parliamentary review at some stage of actions of the executive. I think this is very much in the center of how things are gone. I will now give the floor to Kouroutakis, who is assistant professor in the University of Madrid, has already taught courses in the City University of Hong Kong, the Free University of Berlin, the University of Sao Paulo, the University of Vasiliki.
Thank you very much.
He's interested in the concept of separation of powers, rule of law, emergency legislation. So we are happy to listen to you and learn this on the lessons learned, or to be learned still, perhaps, from the Greek case.
Well, thank you very much for this generous introduction. I would like to thank the organizers for putting together a very interesting panels from and examining the topic from different perspectives. My perspective would be from the inside of the constitutional order, and the main question would be about the role of the courts, about the role of the judiciary when we have the proclamation of a state of emergency. And if I ask you, we have already seen the impact of the Greek case. What if today in Greece the government declares a state of emergency? Can we challenge that decision before the courts? Let me start with the idea of constitutionalism. Modern democracies, they are found on the idea of limited government. Government is limited because a constitution, written or unwritten, sets some limits. We have two types of constitutionalism. We have what we call political constitutionalism, where the presence of the courts is limited. The courts, they don't have the power to strike down acts of parliament. They show restraint. They adjudicate private law cases, or they might adjudicate cases regarding the executive vis-à-vis the legislative branch. It is based on the promise that the self-correctness of politics will solve every problem. On the other hand, we have a completely different model, the model of legal constitutionalism. And the idea here is that we have the courts as watchdogs, as safeguards, as protectors of the Constitution and of the constitutional principles. Within this classification, within the model of legal constitutionalism, courts have a quite important role, a significant role. At the same time, from the practice of the courts, we have seen that in some areas they show activism, in other areas they show restraint. For different reasons. For instance, in financial, when they adjudicate financial disputes, because they lack the expertise, the courts are very keen to show restraint. What about emergencies? So I need to, we need to go back to history in order to see the spirit that we have during emergencies. And we trace the discussion on emergencies in the Roman period. From the streets of Cicero, we know that when, in times of war, the laws are silent. We know that during the Enlightenment and after the Enlightenment, the common understanding was that emergencies is a political process unrestricted from law. It is the prerogative of politics. We know that Carl Schmitt, he associated the idea of sovereignty with the power to declare a state of emergency. So the institution that has the power to declare the state of emergency is the sovereign. So all this is just an introduction for the following issue. What about the role of the courts in a state of emergency? We have here some separation of powers concern. The main idea is that emergencies is public politics. And since it is a political issue, the political branch of the government, the branch of the government being elected by the people, they should have the first and the final word in that area. There is also, from a legal point of view, the question whether an emergency is a topic that courts can adjudicate, whether emergencies is a question of fact or it is a question of law. Because if it is a question of fact, you accept it as a fact and you don't question it. So the mainstream approach, even today, is that courts, in times of emergency, they show restraint. They believe that this is a poor political topic. Even in Greece, during the years of the crisis, governments, they passed a number of laws, ordinances, claiming that it was an emergency. And we know that the courts, they didn't show the activism to intervene. Even the referendum that we had here in Greece, the foundation of the referendum in 2015 was based on an ordinance. The government claimed that there is an emergency, and that's why they have to change the law with an ordinance. And the courts didn't adjudicate the case. So, what is the problem with emergencies? We have two major problems. The first problem is that the separation of powers is distorted. We have concentration of powers in the hands of the executive. There is danger of the collapse of the constitutional order. There is the danger of dictatorships. We have, in the past, the case of the Weimar Republic, when Hitler, with a completely legal way, he gained power, he used emergency provisions, and he dissolved and he, destroyed the constitution of the Weimar Republic. There was an interesting story there. I was reading that story, and in 1932, the Chancellor ordered, with an emergency provision, the dissolution of the government in Prussia, a state, Lund, in Germany. And he appointed von Papen as the commissioner of that area. At that time, the local government there were the Social Democrats. And that was, according to historians, a very critical moment, because the question was at that time whether the dissatisfaction of the people will be absorbed by the Nazis or by the Social Democrats. And the state of Prussia challenged that decision, that emergency decision of the Chancellor before the courts. And Smith, along with 4 lawyers, they argued that the courts, they don't have the power to adjudicate on that topic because it's purely political. Also, emergencies, they create concerns because what we have in emergencies is actually dejudification. In extreme situations, we have black holes like Guantanamo. But what is dejudification? It is the silence of major human rights provisions. And I will bring to you here another story. We are in the Civil War in the US. The states of the South, they want their independence. They don't obey the Constitution. And Lincoln, he suspends habeas corpus. But according to the Constitution, only the Congress has the power to suspend the Constitution. And Lincoln famously said that, well, we have some countries that they do not respect any provision of the Constitution. And it would be a problem if I do not respect one provision of the Constitution. Later on, Justice Jackson said in a case that the Constitution and human rights can become a suicide pact in the state of emergency. So, about the judiciary. Can the judiciary adjudicate and discuss the state of emergency? The first issue is that the court and judges, they have limited legitimacy. Democracies, they have 2 very important principles: accountability and legitimacy. This is the fuel of democracy. So judges, they have limited legitimacy because they are appointed by the political branches of the government, but that's it. But what brings legitimacy in this branch is their institutional expertise. It is the way they draft their decision, it is their justification, it is their reason. It is not whether we agree or we disagree with the outcome of the case. I have read very interesting cases, very important cases. I agreed or disagreed with the outcome, but what is more important, it is the reasoning, the justification. And this led me to the Greek case. It was mentioned before, a very important paragraph in the Greek case. The court, with 4 lines, in reality, created a test. It had to decide whether the claim from the Greek junta that they are in a state of emergency, and that's why they derogate from the provisions, whether this state of emergency exists or not. So in order to respond to that question, they created a test. They said that, well, this emergency must be actual or imminent. They said that it must threaten the whole of the nation. This is about the quantity. About the quality, they said that about the value, that it has to threaten the organizing life of the people. And they said that it has to be an exception where we need extraordinary means, because the ordinary tools that we have, they are not efficient. This is a prime example of a very good case where judges, they meet the standards of the judiciary as watchdogs of human rights and of the constitutional order. And this is why the Greek case is a landmark case. Because with this case here, we have a test. What is the important? We have a checklist. What is the importance of this checklist? Well, in the hospitals, they face emergency. It's very common. And the way doctors work is a checklist. Pilots, when they face a problem, they open their books and they go to their checklist. There's a procedure. So courts, when they draft cases, when they want to bring legitimacy to their cases, they need very good justification, very good reasoning. I feel that there is another element in emergencies. They should be temporary. Emergencies, by default, they should be temporary. For instance, the case that we have in Israel, it is a colleague of mine wrote a book about the permanent state of emergency. It is relevant to climate change. We need to distinguish when we discuss about a regime which is temporary, that we can reverse it, and the new normality. So, with that said, I would like to make another distinction between crisis and emergencies. Brexit is a crisis, it's not an emergency. And it is a crisis because the Brexit was not unexpected. Emergencies, by default, should be unexpected. So in these 4 criteria posed by the Commission, I would add 2 more. The element of time, temporary, which is implied by the provision because derogation is time limited, and the fact of that it should be unexpected. So with that said, thank you very much.
Thank you very much, Adonis. That was really eye-opening, I would say, about how the judicial control should work in cases of emergency. I'm sure that you will have questions to Adonis at a later stage. Now I would like to give the floor to Hochmann. Hochmann is a professor at the University of Reims-Champagne, Ardennes. Has made publications on genocide, the négationnisme face aux limites de la liberté d'expression, which is extremely important. He is also about to publish, or has just been published, the 50 Shades of Illiberal Democracy, which is a very interesting title, and that I'm sure that we will all are eager to look into it. But now, for the time being, we are eager to listen to your presentation about the forgotten lessons of the Greek case. You have the floor.
Merci beaucoup, Monsieur le Président. Many thanks, many congratulations to the organizers of this wonderful conference. I would like to propose a way the European Court of Human Rights could respond to the development of illiberal democracies or even more blatant dictatorships. It seems to me that the development of a general system of infringement of liberties cannot be handled in the same manner than some isolated violations by a liberal government. In such a situation of an illiberal democracy, it might not be enough to notice decision after decision the numerous violations perpetrated by an illiberal regime. I think the effort to suppress liberal democracy deserves a specific response. And oddly enough, the most adequate provision to formulate this response is hardly ever mentioned in the literature or in the case law. This response, I think, is Article 17 of the European Convention on Human Rights. I read it. Nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein. So Article 17 of the Convention forbids any state to engage in any activity aimed at the destruction of the rights provided in the Convention. This rule was mentioned in the Greek case by two members of the Commission, but since then it has been forgotten. It seems maybe, however, about to emerge again. So the aim of the paper is to recall this forgotten lesson from the Greek case. The best known rule stemming from Article 17 applies to individuals. It excludes from the protection of the Convention the activities of an individual or group that aimed at the destruction of the rights guaranteed by the Convention. But once again, it's often forgotten that Article 17 also edicts the same prohibition towards states. It forbids them to aim at the destruction of the guaranteed freedoms. So the state cannot rely on the Convention to pursue such a goal. The Convention allows, of course, for rights restrictions, but the state cannot invoke the permissions to restrict freedoms if it's actually working towards their destruction. So I think Article 17 is a tool, and I would argue the best tool against illiberal governments. The letter of Article 17 should suffice to establish this interpretation. However, several additional elements plead for the recognition of this interpretation of Article 17. First, from a teleological point of view, Article 17 is a mechanism of militant democracy. It aims to prevent the destruction of liberal democracy. So there is no reason to consider that Article 17 would only seek to prevent the opponents of liberal democracy from gaining power, but that it would cease to apply once they have succeeded. It also opposes the destruction of freedoms when it is perpetrated by the state. It's precisely in such a situation that the danger to freedom is the greatest. From a historical point of view, then, it may be noted that this component of Article 17 was perfectly intended by its drafters. The word state in the provision was added in Article 30 of the Universal Declaration of Human Rights, who served as a model for Article 17. And it was never questioned during the elaboration of the convention. It's true that the travaux préparatoires are not very eloquent on this provision, but several interventions show that the supporters of Article 17 did not only care about illiberal movements, but also about totalitarian states. In the Greek case, as I said, two members of the Commission had not hesitated to recognize such a situation and to recommend that Article 17 be applied accordingly. As more or less illiberal regimes develop now, under the eyes of our President and of the Council of Europe, it might be time to remember this lesson and to resort to this tool. Several members of the European Court of Human Rights are aware of this, and we assist to a revival of this interpretation of Article 17. It appeared in the opinion joined by several judges in the Navalny versus Russia judgment that was delivered by the Grand Chamber of the Court in November 2018. As you may know, the political opponent, Alexei Navalny, complained to the court about several arrests he had been subjected to on various occasions. In the absence of valid reasons for these arrests, the court identified several violations of the conventions. And above all, the court held that Russia had violated Article 18, which prohibits misuse of power. The court considered that the applicant's arrests were pursuing an ulterior purpose, namely to suppress the political pluralism which forms part of effective political democracy, I quote the judgment. And in other words, as the applicant pointed out, the treatment to which he had been subjected attained the very essence of democracy. But if that were the case, would the relevant provision not be Article 17 rather than Article 18? Article 18 refers in an undifferentiated manner to any application of a restriction for a purpose other than those for which it has been prescribed. But when an effort to suppress democracy is undergoing, Article 17 seems more relevant. 5 judges of the court made no mistake in this regard. In their partly concurring and partly dissenting opinion, they defended the relevance of Article 17 in such a situation. They recognized the absence of case law on this point, the Greek case being explicitly mentioned at the only beginning of a precedent. But they insisted that Article 17 was capable of applying to any act or activity of the state aimed at the destruction of any of the rights and freedom set forth in the Convention. Referring to the travaux préparatoires, the 5 judges state that from its very beginning, I quote, Article 17 was aimed not only at enabling states to take measures against threats from groups or individuals to democratic society, but also, and perhaps even more so, they say, at preventing states from a totalitarian drift. As you know, separate opinions are sometimes the source of major jurisprudential developments. And there are indeed several reasons why the proposal of these judges deserves to be considered by the whole court in the future. First, and as the judges explain, Article 17 has several advantages over Article 18. Article 18 is more difficult to apply than Article 17 because it requires to demonstrate a predominant illegal purpose hidden behind a legitimate motive. And as we know in French administrative law, which was the inspiration for this Article 18, such investigation in the hidden goals of a state is very difficult. Secondly, Article 17 goes beyond the establishment of an isolated violation to reveal the existence of a system hostile to liberal democracy. With Article 17, the court can condemn systemic violations aimed at the destruction of the rights provided by the Convention. Thirdly, the third advantage of Article 17 is perhaps more a matter of judicial policy than of the law itself. It goes without saying that each individual instance of this system of destruction of freedoms constitutes a violation of the Convention, which can always be identified as such by the court. One might therefore wonder about the point of resorting to Article 17. This provision does not seem to allow to establish violation which, without Article 17, would have escaped the vigilance of the court. But the same is true of Article 17 when it's applied against individuals, as the court has sometimes done. The punishment of racists or Holocaust deniers complies with the limits to freedom of expression as provided in Article 10 of the Convention. There is no need to resort to Article 17 to justify those restrictions. Yet, this does not make Article 17 useless. Its importance lies in its symbolic function. It's the strong message conveyed by its application. And this is all the more relevant when the opponents of freedom occupy state functions. Applying Article 17 in such a situation tells public officials that they may not invoke the permissions to restrict freedoms in order to work toward their destruction. However, this contemplated use of Article 17 raises a political problem. It might be argued that it would be a counterproductive measure. By accusing a state to work for the destruction of liberties, the court takes the risk, it was mentioned earlier today, the court takes the risk to offend the state. Therefore, the harsh decision to apply Article 17 might be counterproductive in the sense that it could lead to a denunciation of the convention by the affected state. So this stunning move by the court would ultimately lead to abandoning the population of the concerned state. Without wishing to settle this dilemma here, I think one can imagine several counter-arguments in favor of the application of Article 17. First, and we talked about it today, it's not sure that the court is really in a position to effectively protect people persecuted by an illiberal regime. The multiplicity of violations leads to a very large number of applications that may overwhelm the court, and the sentences it hands down are not always of great effect. If the court cannot prevent the establishment of a totalitarian regime in a member state, then should it not at least describe these states clearly for what they are? Second, illiberal regimes nowadays attach considerable importance to the appearance of their deeds. Or so I thought before I heard Professor Bednek. It seemed to me that these countries act always under color of law, and they often purport to respect the very values they are attacking. It's therefore far from certain that they will dare to take the very telling decision to denounce a major convention on human rights. And what if they do? Is it so problematic that an illiberal regime leaves the European Convention on Human Rights? My third argument is that the place of such a state might be outside the Convention. The Convention may not survive long if it counts among its state parties governments that flout the rights it guarantees. The Convention contains red lines, as we heard today, and Article 17 is there to sound the alarm when those lines are crossed. So, I think Article 17 was designed specifically to deal with the situation currently facing the European Court of Human Rights, or the Council of Europe. And it's therefore time to remember this tool mentioned for the first time in the Greek case. I think this lesson from a tragic past might be useful in our alarming present. Thank you very much.
Merci beaucoup, Thomas. This is a real novelty, I would say, perhaps based on the Greek case, but it opens another window of interpretation of Article 17. A whole new world. Usually, you know, Article 17 prohibits individuals from invoking rights and liberties in the Convention when they are supposed to use these rights and liberties to destroy the rights of the Convention. So, pas d'ennemis pour les ennemis de la liberté, pas de liberté pour les ennemis de la liberté. C'est injuste, I think. Yes. So this is the logic of Article 17. From the other side, states are, because of Article 17, allowed to take measures in order to limit the rights and freedoms of those who will use them against liberties, let's say, rights and freedoms. And this has been sometimes criticized because it opens a window for abusive restrictions from member states. So this is a completely different interpretation based on the same wording. I have a question which I will raise to you afterwards, but since this is very much linked to what we're discussing now, I have the pleasure to give the floor to Isabella Risini. Isabella is a postdoctoral researcher at the Faculty of Law in Ruhr University in Bochum. Her research focuses on European international human rights law, public international European law. For me, what is most important is she has extensively published on European Convention of Human Rights, in particular on the interstate application. And since we said, as we said this morning and yesterday, that there are increasingly now interstate applications coming in Strasbourg, sometimes also with thousands of individual applications at the same time concerning the same topic. I am very eager to listen to Isabella. You have the floor.
Thank you. Thank you very much for the kind introduction. Thank you, a word to the organizers for putting this together, and thank you for also inviting people like you. So I was very happy to talk to you and to hear about the backgrounds of Maria that I hadn't come across despite my already long-standing academic interest in this. So I've learned a lot. I would want to really mention that I've valued this very much. Now I find myself in the position to talk about the future on a conference about organized by historians, so this is not an easy way to start this out, and I promise it's only 4 slides, so we're almost there. It's late in the day, and also Professor Benedek has already said a lot about what I was covering, so I will try to keep it short, and I'm looking forward to the discussion later. So the longer title was this. I've now narrowed it a little bit down, and I'm trying to say some brief words about things that have come up before. So this is indeed the publication that the chair was referring to, and I've been trying there to connect some of the dots between the first Greek case of Greece that applied against the United Kingdom at the time when Cyprus was still under a colony, until also what happened after the Greek case, namely the Cyprus litigation that is somehow still with us after so many decades of litigation. That was a direct result of the intervention of Turkey on Cyprus. So this is maybe something that I can refer you to with some broader strokes, also the historical context of all interstate applications that we have seen until 2016. So that is already, and this is now a bit the overview of what I wanted to talk about today. So Strasbourg today. Strasbourg is a court now that deals with currently some 60,000 individual applications and 8 sets of interstate applications. And one can say it's a busy court. It's a busy court, and this is something that blends very much into what we are now trying to discuss here. It is a forum convenience in many ways. It is easy for states to come to Strasbourg. There's basically very few requirements that have to be met in order to bring a case in Strasbourg. So this is somehow the court as a victim of its own success. So we see a very, very busy court at the moment. Its yardstick is the European Convention on Human Rights, and that's also the limitation. So it cannot review certain things by the yardstick of, for example, international humanitarian law, or by the yardstick of the jus ad bellum, use of force, things like that. So this is a bit the situation that the busy Strasbourg court faces now. From an institutional background, we see that the Council of Europe now, that started out with basically 2 organs, so the what is now called the Parliamentary Assembly and the Committee of Ministers. Now we see, and Professor Benedek already alluded to this, a multitude of organs or sub-organs, or, well, not even to call it them organs, but bodies that deal with certain aspects. So, for example, the Committee Against Torture or the Venice Commission, all kinds of bodies that deal with certain aspects, which is a good thing on the one hand and a bad thing on the other, because that takes away the attention from what happens maybe in the court, if you see this as the most important place that the Council of Europe has created as such. We also see from the outside that there are many other fora today available to litigate certain cases. And if you see the actual cases that are now pending against Russia, Ukraine especially has made use of its possibilities to argue cases in all available fora on this planet. So this also takes away some of the attention from Strasbourg. It's certainly a good thing too, because we've all been, as international lawyers, working towards opening up fora to litigate certain matters, but it also raises certain questions about how to deal with parallel litigation and how to sort of deal with the multitude of fora. It's also, again, difficult then to attract attention to certain decisions that deserve maybe more attention than they have been receiving. The centerpiece of what I'm gonna be talking about a little bit more in depth today is now fact-finding. So fact-finding is one of the things that the Greek case was really all about. So some 20,000 pages of documents were produced, also with the help of outsiders. So 20,000 or so pages, that's a lot. And then the Commission managed to somehow bring it down to only 1,100 pages of a report, which is also already a big achievement. So that takes a lot of resources. So the part-time Commission, at that time it was a part-time organ, it took almost all of their time and effort to deal with this Greek case, and rightly so that was important. Today we have, as I said, a busy court. A busy court that faces many interstate applications where the court finds itself in a position of a court of first instance in many ways, because many times the facts have been not ascertained, they are controversial, and if we dispense with the domestic remedies, as was proposed by many speakers, that means that the facts have been not ascertained by national judiciary bodies or proceedings. So resource is really a big problem and a big bottleneck, if you want to put it that way. And also it is something that is a question of the length of proceedings. So how long does it take for a court to go through all of these cases that raise very, very many actually factual questions of exercise of control, at what time, who was exercising what kind of control and where. So that makes it a very, very difficult task for a very, very busy court. The value of fact-finding, I think, has emerged clearly on this conference. So fact-finding means putting things on record, having some kind of modest, at least historic truth put out there. So of course it also has limitations. However, this is a key aspect of such proceedings, and I would like to modestly differ maybe from my colleagues or of you. So also there is a limitation of what an institution like the European Court of Human Rights can do in view of backsliding. So yes, we can apply Article 17 and 18 and we can find clear words of condemnation. However, what happens inside a state is something that really is not up to an international court or body or something that cannot really change anything there. So there are far, far away a couple of judges that can pass judgment on something, but they cannot change the situation on the ground very much. So I want not to be too gloomy, and I think the Greek case has been also an example of saving lives of individuals. Possibly, it's also very difficult to do hypothesis here, but possibly limiting the practice of torture in Greece. Who knows? That is a hope that one can have. Who knows that? So it's certainly something important, but there are limitations of an institution like Strasbourg, like the Council of Europe as such, that can influence countries. So I would also like to mention maybe a book that recently I've come across by Hurst Hannum, a radically moderate approach to save human rights. So to see and understand what the limitations of human rights are in order to not expect too much of a court to solve problems that are deeply rooted in all kinds of historical contexts and have well, dimensions beyond something that can be solved by a court of law. A few words I would like to add on the role as a democracy watchdog. So democracy is also a big word, and I would also like to be very careful with trying to somehow assign this role to the European Court of Human Rights. One commentator wrote about the Greek case that the Commission always tried to see the trees and never the forest when it came to also the way they treated the derogation clauses. So they did not, I want to underline this, they did not question in general the possibility of an illegitimate government to declare a state of emergency. So that's, I think, a very interesting observation that it was not as such questioned that who was giving the state of emergency, but they looked at the modalities. So democracy, as I said, is a big word, and one would need to think a bit more about whether something like democracy is something that can be translated into individual human rights, which is something that I would see as highly questionable. There is an additional protocol to the convention that contains the right to free elections, also was something very controversial. The Commission had prepared well, some kind of proposals to hold free elections in Greece as an aspect of its work. Maybe that would have worked if somebody had listened to them. But as I said, democracy is a very big word, and I would not expect too much of the court. Yes, it can find clear words, and it should do so, but I think also the application of norms like 18 and 17 probably will not stop Azerbaijan from doing what they do. I'm coming to the end. So now if we look at Russia and Turkey today, and maybe I wanted to add, so many interstate cases have not been brought in Strasbourg, where they would have been an appropriate tool, especially I think Turkey since 2016. Russia has also been keeping the court busy, and now what comes to this is a credibility problem at some point. So if we see what happened over the summer with Russia, well, one can ask what is better, to have them in or out? And the same question discussed with respect to the Greek case. So was it a good thing to sort of have this exit forcibly or not forcibly? Or would it have been better to keep Greece inside the Council of Europe and try to talk to them and try to convince them of holding free elections, which is somehow maybe a far-fetched idea. So what about today? Is it better to remain in dialogue with Russia and Turkey or not? And would we deprive Russians and Turkish people of the right of individual petition? That's maybe one argument that has been raised and is probably a valid argument and was not applicable in the Greek times because Greece had not accepted the right of individual petition at the time. So I wouldn't be able to really offer an answer there. I think dialogue is a good thing. It's best that we have. I think it doesn't get better if we don't want to use tanks. I would close it with that, and thank you again for your kind attention, for putting this together, and for listening to me.
Thousand thanks, Isabella. Thank you very much for putting so much focus on fact-finding. I think that also in the previous discussion, all this discussion that we had about the witnesses is very much about fact-finding and about proving, about the proof and evidence beyond reasonable doubt. I think some of the previous speakers, the previous panel said, everybody knew that there was torture in this. Yes, probably everybody knew. But the difference was made because a body, on the basis of a procedure which had been agreed by Greece, on the basis of modalities that had been agreed by Greece, on the basis of texts that had been agreed by Greece, in which Greece had participated, managed to prove beyond reasonable doubt that torture was taking place. And this is the difference of the procedure. Because of course we have plenty of NGOs that are able to say what is happening. Information is circulating today, very often. And the essence and what makes the difference is the fact that the state itself participates in this procedure which takes place in accordance with the process that they have agreed to, on the basis of principles they have agreed to. From this perspective, the way the court will deal with the new interstate applications is of extreme importance, of course, because if they don't stick to a very serious fact-finding operation, then the whole interest will no longer be on the violations, but on the procedure. And we know that some of the states concerned have a genuine capacity of diverting substance towards procedure in diplomacy. So thank you very much again. And we were a very disciplined panel, actually, so we still have